everyone, it's Justin here from First National Bundaberg. Today I want to talk about a big change coming to selling property in Queensland. On 1st of August 2025, new seller disclosure laws kick in, and if you're a home seller or thinking of becoming one, you'll want to know what this means for you. This is one of the most significant property changes we've seen in decades. So let's break it down in plain English. First off, what is this new law? In a nutshell, from 1st of August 2025 onward, every residential property seller in Queensland must provide a formal seller disclosure statement. That's officially called Form 2, along with certain prescribed documents before a buyer signs the contract. Emphasis on before. This is a big shift from the old days of buyer beware. It used to be mostly on buyers to do their own checks and searches. Now the responsibility is shared. Sellers have to proactively hand over key information about the property up front. In fact, under the new Property Law Act, you cannot even legally finalise a sale contract without giving the buyer this disclosure statement first. No Form 2, no contract. That's the new rule. And it applies to all standard sales of houses, units, residential land, basically any normal real estate contract signed on or after 1st of August, no matter when you first listed the property for sale. So what exactly do you need to disclose? Quite a lot, honestly. It's not just a one-page form with your name and address. The Form 2 statement is comprehensive. It covers multiple categories of information about your property. For example, you'll start with basic seller property details, your name, the property address, the title reference, and whether it's a part of a community title scheme, like a unit or a townhouse complex. Then it dives into title encumbrances. This means you need to include things like current title search showing who owns the property and any registered encumbrances on the title, such as a mortgage, easement, or caveat. If there are unregistered encumbrances or agreements, those have to be disclosed too. Think of situations like an unregistered lease or an informal agreement you might have. For instance, maybe you've allowed a neighbour to use part of your land, or you have a mining access agreement, or even a verbal agreement with someone that will continue after the sale. Those need to be brought to light. You'll list any leases or tenancies in place, like if you've been renting the property out, you'd note the tenancy details. Essentially, any interest or agreement affecting the property that a new owner should know about, whether it's officially on the title or not, has to go into the statement. The disclosure statement also asks about the land use, planning and environment matters. This is really important stuff that people often don't think about. For example, zoning. What is the property zoned for under the local council plan? Is it in any special development area? Buyers will want to know that. Are there any infrastructure proposals or notices that affect the land? Imagine if the Department of Transport or the local council has given you a notice that they intend to resume part of your land for a new road or a railway, or maybe there's a plan to widen the street. That's the kind of thing you must disclose. If you've received a formal notice of intention to resume from an authority, the buyer needs to see it. Environmental issues are another key part. You'll have to state if the property is listed on the Environmental Management Register or Contaminated Land Register, which means at some point the land has been identified as potentially contaminated or needing environmental management. If there have been any environmental orders or notices, like a notice to clean up contamination or any obligations, those must be disclosed as well. Essentially, if the government has ever notified you that, hey, your property has X issue, whether X is an environmental concern, a planned infrastructure project, or anything that could affect the land's use, it goes in the disclosure. Moving on, there's a section about buildings and safety. If you have structures on the property, there are a few specific things to cover. One is pool safety. If your property has a pool, you'll need a valid pool safety certificate included. Another is if you've done any building work as an owner builder in recent years. For instance, you built a deck or an extension yourself, you may need to disclose if there's any owner-builder notice or permit. The form will also require disclosure of certain notices, like any show cause or enforcement orders from council. For example, if council has ever issued an order about an unapproved structure or a safety issue, maybe a balcony that wasn't approved or a shed built too close to the boundary that council flagged, that's something a buyer needs to know going in. Basically, any official notices about building or structures on the land must be laid out. The disclosure statement even covers the everyday stuff like rates and utilities. You'll be stating the amount of the latest rates notice, water charges, and whether there are any unpaid amounts owing that a buyer would potentially have to take on. If the property is part of a community title scheme, like a body corporate, you'll need to provide details on that too. Things like what the contributions are, and include a copy of the Community Management Statement, the CMS, and other relevant body corporate information. In other words, the buyer should be given a clear picture of any ongoing costs or obligations tied to the property. I know that's a lot of information. The idea is that a buyer shouldn't be blindsided by anything after they've signed the contract. They shouldn't discover at the last minute that, say, the house is about to be impacted by a road widening project, or that the beautiful extension on the home was actually done by the owner without final approvals. All of that needs to be on the table up front. Think of it from your perspective. If you were buying, you'd want these details up front too, right? It's about transparency. So, the law is basically saying, let's make sure the buyer has all the key facts in front of them from day one. Now let's talk timing and process. As I mentioned, you have to give this disclosure statement to the buyer before they sign the contract. In practical terms, that means as a seller, you'll want to have this Form 2 and all the attachments ready, ideally as soon as you start negotiating with the buyer. Honestly, it's best to have it ready even when you start marketing the property. We at First National are advising all our sellers, prepare your disclosure documents as early as possible, definitely before you accept any offer. Because once the new law is in effect, you simply cannot have a binding contract without it. If a buyer is ready to sign and you don't have the disclosure done, you're going to delay the deal or risk turning them off. And worse, if somehow you proceed without giving it or gave an incomplete one, you're exposing yourself to a lot of risk. What risk exactly? Here's the crucial part. If you fail to give the buyer the required disclosure, or if the disclosure you give is materially inaccurate or incomplete, the buyer will have a statutory right to terminate the contract at any time up until settlement. That means the buyer could sign the contract, move forward initially, but later, even on the day before settlement, say, actually, you didn't give me a proper disclosure, so I'm voiding this contract. They'd be legally entitled to walk away and get their full deposit refunded. You can imagine how devastating that would be after weeks of thinking your property was sold. You might have even committed to buying something else, only have your sale collapse. It's not a situation you want to be in, and it doesn't stop at just losing the buyer. If that buyer backed out because you missed something important in the disclosure, you could potentially be liable for costs. For instance, if the buyer spent money on inspections or legal fees, they could seek to recover those because the deal fell over due to the disclosure issue. In short, cutting corners on this disclosure can cost you far more in the long run. A cheap, half-done disclosure pack isn't worth the risk. It could literally cost you the sale and more. The sale doesn't allow any special conditions to the contract out of this either. You can't have the buyer agree to waive the disclosure or sign a waiver. That won't be legally effective. The requirement is mandatory. So, the only path or safe path is doing it right the first time. Now, I don't say all that to scare you, rather, I want to underscore how important it is to treat this seriously. The good news is, if you do it properly, it actually benefits everyone. Buyers will have more confidence because everything's transparent, and you, as the seller, get a smoother transaction with less chance of the deal falling apart over a surprise. In fact, a well-prepared disclosure can speed up a buyer due diligence. When a buyer sees you've already provided a stack of documents, title searches, certificates, etc., they know you're organised and honest. And that can only help your sale. So how do we help with this? As your real estate agency, we've been gearing up for these new laws for a while. We can guide you through the whole disclosure process. Now, by law, the seller is the one responsible for the accuracy of the disclosure. You have a few options to get it done. You can prepare the form to yourself, though most people get some help. You can have a solicitor handle it for you, which is a great idea because they know the legal ins and outs. Or you can authorise your real estate agent, that's us, to prepare the disclosure statement on your behalf. Many of our clients choose a combination. We coordinate a lot of the practical work and searches while their solicitor double checks the legal details. Here at First National Bundaberg, we're happy to take on the heavy lifting of assembling the disclosure documents. What does that mean? Well, we can gather the required searches and certificates for you. For example, we'll obtain an up-to-date title search and survey plan. We'll check if there are any easements or encumbrances and make sure those are documented. We might ask you a series of questions, kind of like a questionnaire, about things we wouldn't know just for the records. Like if you have any unregistered agreements or if you've had any notices from authorities, if needed. With your permission, we can also do things like a council search for any notices or approvals on file. Check the contaminated land register, get a rates and water certificate, and so on. Basically, we'll use our resources and checklists to ensure that every required piece of information is collected. Once we have all that, we can fill out the Form 2 for you to review and sign. Remember, the form has to be signed by the seller, you, to be valid, either physically or electronically. We'll make sure it's all in order. And then when we're dealing with a potential buyer, we can present this disclosure statement to them confidently. If at any point there's something unusual or complex, say we discover an old agreement or a legal quirk with your property, we'll likely advise looping in your solicitor to make sure it's handled correctly. We're not lawyers and we don't give you legal advice, but we work alongside your legal team to get everything right. A practical tip here, plan for a bit of time to get this done. Some of these searches, like certain council or environmental searches, can take several days or more to come back. So this isn't a do it the night before signing kind of task. Ideally, when you decide to put your property on the market, or at least once you start getting serious interest, that's the time to kick off. Gathering these disclosures documents. It might feel early, but trust me, you'll be glad to have it ready. This way, when an offer does come in and you want to accept, you won't have to say, hang on, we need a week to do the paperwork. You'll already have it. To hand over, and the contract process can move ahead smoothly. Some people have asked, does this cover absolutely everything I need to know about a property? The answer is not quite everything. Even with this new law, the old advice of buyers should do their own due diligence still holds true. For example, the disclosure statement doesn't necessarily cover things like past flood history or whether there might be termites or if the aircon is about to break. Those kind of property condition details it's mostly about legal and council records and formal information. So buyers will still do inspection and ask questions about the form too, but what the seller's disclosure does is establish a baseline of critical information every buyer is entitled up front. It sets a consistent standard across all sales, which is actually helpful because everyone knows what to expect. To wrap up here are the key takeaways. Starting 1 August 2025, Queensland law requires home sellers to provide a signed seller disclosure statement, Form 2, and all required certificates to the buyer before the contract is signed. This statement includes details about the seller and property title and any encumbrances or leases, zoning, and any government notices like resumptions or infrastructure projects, environmental or contamination listings, building and safety info, think pool certificates or any council orders, and basic rates, water and body corporate details if relevant. It's a comprehensive dossier on the property. If you don't provide it or if it's incomplete or incorrect, the buyer can cancel the contract any time up until settlement and get their deposit back, leaving you back at square one and possibly worse. There's no opting out of this. It's mandatory for almost all normal sales. So the only option is to comply and do it properly. The positive side is that with everything disclosed, there's less chance for disputes or surprises down the track. It fosters transparency and trust in the sale, and you're not alone in this. Your real estate agent can help make it happen smoothly. Here at First National Bundaberg, we're making sure all our sellers are well prepared. We'll help you understand exactly what info is needed, help collect it, and work with your solicitor as needed to double check everything. Yes, it might be more upfront work and there could be some costs for obtaining documents, and I'll say there will be costs for those search fees, but it's a wise investment to protect your sale. If you're planning to sell your property, don't let these new requirements catch you off guard. Get in touch with us early and we'll start the ball rolling on your disclosure documents so you're ready to go. We've created checklists and have resources at hand to streamline this as much as possible for you. Our goal is to take the stress out of it. We handle the nitty-gritty so you can focus on the bigger picture of selling your home. Ultimately, these laws are about giving buyers confidence and protecting sellers from last-minute surprises. By doing the right thing and disclosing everything up front, you're making your sale more secure. It's like insurance. A bit of effort now can save a lot of headache later. And as your agents, we're here to ensure that effort is as painless and effective as possible. Thanks for sticking with me through all that information. I know it was a lot, but it's important. If you have any questions about Queensland's new seller disclosure laws, or you want help getting your disclosure statement ready, just reach out to us at First National Bundaberg. We're here to help you navigate these changes confidently. Selling your home is a big deal, and the last thing you need is an avoidable legal hiccup. With the right preparation, we'll make sure your sale goes off without a hitch, even with the new rules in place. Thanks for watching. Happy selling. Let's make sure you're ready for 1st of August with all the info you need. If you're thinking of selling, now's a great time to chat. We can get everything lined up. Until next time, take care and talk soon.